Hello friends. I wish I were a student in this hall to tease Neelam ma'am more. It's her good luck and my bad luck. Anyways, thank you so much for having me here, calling me here and giving me opportunity to talk to you all. Uh, it's compulsory lecture without a break. I can't help it. In front of her, I can't talk anything. So now you have to bear with me. Huh? Okay, so what is the topic today for me? Any clue? You have the copy of your schedule? Do you have? Okay. Anybody is helping me by the presentation? Yes. It's just one file. So delay there, I took opportunity to take your test. So I won't play a role of a teacher. I'm just being here as a communicator and convey a couple of thoughts and a piece of information, pass on piece of information to you on role of citizens in legislative processes. So to begin with, any example you wish to share where you've seen citizens participated in lawmaking process? Any example you wish to share? Okay. And who is going to operate it? Okay, great. तो कोई एग्जाम्पल है जहाँ लोग सिटीजन पार्टिसिपेट हुए हैं लॉ मेकिंग के लिए में निर्भया इंसिडेंट्स yes, that's great. So what was the role of people? Okay, people came on the street, protested, and people demanded certain changes in the existing law and law implementation. Any change in the law came? Do you think post Nirbhaya you saw any change in the law? Or there was ordinance? What was the instrumental activity post Nirbhaya? It's Verma committee report, isn't it? Justice Verma, the committee under the headship of Justice Verma, committee came up with very crucial recommendations pertaining to the changes in existing laws, including implementation of the law. The ways you implement the law, the evidence is taken on record, the treatment that is given to the complainant. So, and the very important point is the Verma committee went through huge number of records, cases, had consultation with a large number of citizens and civil society organizations. On that basis, the recommendations had come up. Any idea what happened with the recommendations? What is the stage of the recommendations now? Post BNS, certain recommendations are incorporated in the new law. Now we don't have IPC and Indian Evidence Act. We have BNS and BNNS. Okay. Let me know which class the students are from.
Law students are there, MBA management students are there, pharmacy students are there. So,
And
almost from all diaspora students are.
okay. And law students which year? Third year. So BNS and BNNS you know. Indian Penal Code, which was the law previously taking care of definition of crimes, definition of the kind of punishment the particular crime attracts, and the kind of crime, whether it is non-cognizable, cognizable, bailable, non-bailable, all sort of compartmentalization was there in the IPC previously. Now we have post July 23, we have Bharatiya Nyaya Samhita, and BNNS. Huh? And also Saksha Samhita. Three legislations undergone changed completely. They're replaced. Rather, they changed, they're replaced by three sets of completely new laws. Now, what is the role of citizens? Yesterday, you had a discussion with about the role of citizens in administration. Kalyan talked about it.
Kalyan downside was on another.
Not here.
Few of them must have.
Okay, okay. So, anyways, no harm. So we have history of people's participation. Huh? We need to start talking about concepts like democracy. What is democracy? What is democracy? Please be quick. I don't know what is democracy. When your teacher is not allowing you out, it's not democracy. Joking. What is democracy? Next.
We had
Next.
section in the morning as well today on democracy itself.
In your language. You may or may not use legal or technical terminology. Please.
A government where the power lies with people.
Yeah, that's great. Huh? And rule by the people, for the people. Huh?
Democracy is a form of government where the power lies with the people.
Okay. Is that coming from your screen?
No, ma'am, actually you only have.
I'm just inquiring. These days, the students are depending more and more on IA. So I was curious to know whether the responses are spontaneous or coming through your internet screens, etc. Anyways, so today is very important day, 134th birth anniversary of great thinker Dr. Babasaheb Ambedkar. We should memorize him and cherish his work. Thank you. So, and I'm happy that on this day I'm having interactions with you all on this topic especially, where people's participation is important in democracy. Indian Constitution has provided huge space for interpretations, for people's participation. That all depends upon how we are creating spaces for ourselves creatively within the lawmaking process. Now, when we talk about Indian Constitution, when we talk about law, we talk about democracy and freedom. Certain concepts, those are, you can see on the board, becomes very crucial and important. Accountability of the government. Transparency. Whatever is taking place within four walls of the Sansad, that is important because that is there for us. So, just digital governance and digital parliament is a simple initiative to take people with you all, and make people familiar with whatever is happening within the four walls of the parliament. But beyond that, we need spaces to see what actually is happening about our rights, because laws are not just for the sake of laws, they are there to protect our rights. Laws are the spaces where we enjoy our rights. We claim our rights. And without laws, without legal provisions, claiming our rights, implementing our own rights, and enjoying rights is not possible. We need somebody, some mechanisms who will prevent the violations. We need some mechanism to approach in case of violations. And so we are the crucial members in the society. People, citizens are the important connect in the democratic functioning. So people, I'm focusing on people. When we say democracy, people, citizens, residents, Hmm? They are important because on their basis, for them, by them, the rules, the state is functioning. And rule. As I said, law, rules, they're important. I'm not going into the details of law, ordinance, etc., etc. I'm generalizing the term law. Hmm? Within the given time span, it may not be possible to go all nitty-gritties. So I'm generalizing the concept of law, and our engagement with the law as far as lawmaking is concerned. So I wish to give an example of CEDAW. Have you read CEDAW? Is there there in the syllabus? It is there? No. CEDAW convention is it's convention. You all know the history of human rights. It's UDHR, the basic document of human rights. Then the covenants come out of it is civil and political rights, covenant on civil and political rights, covenant on economic, social, and cultural rights, and then all specific covenants like CEDAW, Convention on Elimination of All Kinds of Discrimination Against Women. So, in order to prevent the discrimination, this covenant has come. There are different mechanisms. Very important mechanism is shadow reporting. One is state report. We are also party to the CEDAW convention. We are signatory to that. As a party to convention, it's our responsibility, it's the responsibility of the state to submit the report, periodic report, after 3 years. And to ensure the transparency in functioning, to ensure that the state is really committed, there is parallel mechanism, which is shadow report, or you can call it parallel report. Shadow report is the space for civil society organizations. See, shadow will come after some certain object, right? State report is the object, and shadow report will be the parallel report which will be presented by the accredited civil society organizations to the CEDAW committee. In the parallel report, you can press your demands. You can describe the reality about the lives of women, in which areas still discrimination is seen, in which areas state is not effectively functioning to eradicate the discrimination against women, which areas there is still scope for improving the functioning and ensuring that there is no discrimination against women. So, shadow report is a mechanism, according to me, to ensure that the state is really committed to CEDAW, committed to non-discrimination against women, and committed to bringing the real equality in the society, gender-based equality. Other than that, there are other mechanisms like special rapporteur, subject expert who will visit I remember there was special rapporteur on health, there was special rapporteur who visited the jails and observed, screened the real situation in the jails in India, the health machinery for whether it is providing services to women. That observation also CEDAW rapporteur had presented. So such mechanism is checks and balance tactic. You just cannot depend upon the presentation given by the state, but see the other side of the reality also, the other side of the coin also. Similarly, if the international covenant can think about the transparency and parallel mechanisms, why can't the state government think about it? There should be mechanisms to ensure that people say something about their rights, isn't it? So, next, citizens' participation in the governance, in the public administration, and in lawmaking and law implementation is crucial as far as democratic state is concerned. Is the public participation new to us? No, we have history of Gram Sabhas, Caste Panchayat, Khap Panchayat. You all know how the Caste Panchayat, Khap Panchayat uh, work, right? कोणाला माहिती आहे जात पंचायत बघितलेली आहे कोणी? Okay. At least we have idea that caste panchayat exist. The mechanisms like grassroots level, elderly citizens come together and take decision on behalf of the society. This concept is very much there, where the people will take decision. People will take define what is offense. People will define what kind of punishment the offense will attract. These kind of mechanisms were here in India since history. Now, there are criticisms. I'm not at all propagating and promoting such mechanisms. There are some positive things and negative things also, especially the caste hierarchy, the illiteracy in India, the poverty. Certain sections of society will not be able to participate in this decision-making process. So definitely, because of the social reality, because of the economic reality in the country, handful people will always lead the decision-making. And that has been happening as far as this decision-making at the grassroots is concerned. So, but in modern days, because of civil society organizations, because of some sensitive politicians, leaders, and grassroots activists, some changes we can see. A recent and great example I can see is women's Gram Sabhas, the mandatory Mahila Gram Sabha prior to the village Gram Sabha. A day before or on the same day, women's Gram Sabha is made mandatory, where women will be able to raise their concerns, participate in the decision making, and flag their problems and see that their problems are addressed in the main Gram Sabha. Have you visited such women's Gram Sabha? Definitely you should, because it's the basic unit of decision making where a lay person has space to raise their issues and concerns. It's definitely interesting exercise to and worth watching. So Gram Sabhas are given much powers. The list of BPL, below poverty line, will be read and approved from the Gram Sabha. Gram Sabha is the grassroots unit who will give approval to the programs, the beneficiaries of the schemes, and beyond that, certain programs, certain mechanisms are introduced by the state with consultation with the civil society organizations. One of which is rural health framework, where the government, it is mandatory for the government to address take opinions from the village health committees and incorporate their opinions and their concerns in the health plans. So, with the civil society organizations, with the rights-based approach, these activities been taking place since few decades. But now, next, what about laws? These examples are about the implementation of programs and policies and schemes. Next, we need some space to participate in the law implementation and law making process also. Like, there are certain examples where great activism has pushed the lawmaking process, made the lawmaking process democratic, one of which is Right to Information Act. Right to Information Act came as a result of grassroots activism, isn't it? The grassroots activism was effective enough to raise the concerns, raise the issues with Bhrashtachar is too much of used terminology, but malfunctioning in the governance, and demanded transparency in the governance. So Right to Information Act is the example where people participated, people demanded laws, and as a result of grassroots activism, we got the law. Next example can be PCPNDT. You have idea what is PCPNDT Act? Pre-consultation, I'll go into details in a couple of slides, next couple of slides. I'll go ahead. These people participating in the governance, people participating in the lawmaking process is based on one concept, which is democratic deliberations. Democratic deliberations is the tool which may not be legally approved or legally validated, not incorporated in the law directly, but it's the base of it has to be the base of any lawmaking process. One is democracy, another is deliberations. Democratic deliberations. There are spaces. The law amendment process may not be geared to create spaces for democratic deliberations, but as outcome of the lawmaking processes, the spaces have created. For example, 72nd and 73rd Amendment, where grassroots people got some space in the governance and lawmaking process. I won't go into the 72nd and 73rd Amendment. You wish to, anybody is willing to tell what is 73rd Amendment? Okay, that's your homework. That's your homework. Please go and search for 72nd and 73rd Constitutional Amendment, okay? Let's go ahead. Wherever government has taken some initiative in seeking people's reflections in the governance and lawmaking, the results have been excellent. I'll go ahead. Next is, let's skip one slide and go ahead. Which is that? Okay. So, the examples are excellent whenever the deliberations have taken place, because the democratic deliberation is the activity which is geared to create democratic spaces. As we initially said, it's democracy. It is for the people. So the precondition of democratic deliberation is public, and the issues of concerns of public should be publicly debated and not within the four walls, isn't it? The people at large should be able to openly flag their concerns. No concentration of power should be there. If at all you need public participation, there should be fearless environment where people will be able to raise their hands and flag their concerns. So concentration of power will go against the democratic functioning, definitely. The fair and reasonable outcome is the aim for deliberations, such deliberations. And most important, not even constitution is the only script, the script which cannot be changed. Wherever it is going against the rights of people, it has to undergo change. Indian Constitution, the basic document on which all the laws and policies are based, that also has to be flexible and open enough for changing itself, isn't it? The constitutional amendments is the very important feature of the Indian Constitution, which is flexible, which creates scope for people to change according to the changing circumstances. The new and newer laws will come according to address the new and newer complexities of the society. For example, the environment laws. Environmental complications are coming up along with the development. The development is bringing in new complex problems, and so environment laws have to undergo change, and to incorporate, to give space to changes, the constitution has to be flexible enough. So any deliberation will come up with any law or policy that will also have to be flexible enough to incorporate the changing circumstances. Then constant and ongoing deliberation is important feature. Once the deliberation is done, now 5 years you are gone. Huh? Prior to the elections, the leaders will come to the community, come to the people, ask for people's concern. Then after elections, 5 years, they will not have communication with the people. That will not done. That is not done. The democratic deliberations has to be continuously going on and on and on. And the law and the government itself has to provide some mechanisms for people to come together. Like Gram Sabhas in villages, in the urban areas, ward committees are there. Have anybody of you have participated in ward committees or meetings of ward committees? Many people are not aware that ward committees are there, and it's mandatory to have the ward committees and meetings of the ward committees. I request you to please, wherever you stay, please find out in your surrounding whether there is any ward committee, and please be there as an observer or participant in the ward committee. Because that's, again, I'm saying, like in rural area, Gram Sabhas are there. In the urban areas also, these mechanisms are there, which are the basic units, grassroots basic units where people can come and raise their concern. Again, I'm highlighting these issues. Next. So now, in the democracy, one concern is there that there cannot be consensus amongst the different sections of people. I agree. It's difficult to come to consensus because there is diversity in India. People with diverse background, which we call intersectionality, caste, religion, economic strata, education, place of birth, exposure, all sorts of components are there which makes our society diverse. And in such a diverse situation, bringing in consensus is difficult. I understand. But it is not possible to come to consensus, so there should not be deliberation. This will not be done. It's not acceptable. Even if consensus is not possible, you can reach at least common points which are not hazardous to the participants, not going against the interest of the larger sections of the society. So to go closer to the consensus, you have to take efforts. And so ideally you try and struggle for reaching the consensus, you will go at least close to the consensus. And this consensus building process is very important for reaching the law which is inclusive for everybody. One law for all country, one law for crores of population. Isn't it difficult? So to make that law maximum inclusive, this consensus building is inevitable. We cannot proceed without taking efforts of making it inclusive, isn't it? So, and ultimately, it is going to strengthen your democratic processes. It is going to strengthen your democracy, and people's participation will always strengthen your democracy. I would like to give example, as I was saying next. I was talking about PCPNDT Act. Now, law students, what is PCPNDT Act? Without peeping into the window, please try and recall what is PCPNDT Act. Thank you. Thank you. Huh? There is one law which is addressing the declining sex ratio. Ultimate aim is to control the declining sex ratio, but ultimately, I mean, in reality, it is the law which is controlling the mechanisms. Medical practitioners, they are preventive medical practitioners for conducting sex determination, sex selection. Now, interesting. Where are people in the law, in this law? Uh, we all know that there is judge-made law. Hmm? Whatever comments and judgment the Supreme Court of India will give, that judgment and the comments and the ratio that comes up from the particular judgment is binding upon the subordinate courts. That is the thumb rule. It is 144-41 of the Indian Constitution, which is the set principle. Beyond that, if there is no law in a particular area, the judge-made law can be considered, can be treated as a law. So in this piece, about this PCPNDT, the civil society organizations initiated changes in the law through judiciary. There was a law, PNDT, in 1984, which is state-specific. In Maharashtra, there was law on preventive or prevention of prenatal diagnostic, misuse of prenatal diagnostic techniques. Prenatal diagnostic techniques. Now, what is that? How would you know the sex of the fetus? Sonography. See, in 2025 also, when we talk about sex of the fetus, we are talking about sonography. But the technology has gone much beyond that. In 1984, people were aware about sonography as a technology to understand the fetus of the sex of the fetus. And you all know that in the sex selection and sex-based abortion was rampant, and due to that, the sex ratio got disturbed. So we wanted something to curb this practice. Change in mindset, reduce the effect of patriarchy, which will go on and on, which is long-term activity. But what is the immediate way to curb the practice, that is creating changes in the law. So Sehat is the organization which is working on health and health rights, and Masum, another organization, they filed a PIL to the Supreme Court asking for better implementation of the act. Now, in one state, if you ban the sex selection, obviously people who can afford can go to another state and undergo the sex selection examinations, sex determination examinations. So the law in only state will not be sufficient. We need law which is there in all of the in the country, for the country. Whoever are willing to go outside country, let them. But at least in the country, the practice should be banned. So there were demands through the PIL. The demands were strengthening the mechanisms to control the practice, making the health machinery answerable and accountable for the malpractices. It is ultimately misuse of technology, isn't it? The doctors, while taking the Hippocratic oath, they say that they will not misuse the technology and their knowledge against the society. And in reality, they are conducting the sex identification examination. It is against the ethical practices. So controlling the unethical practices in the medical fraternity was the important demand in the PIL. Now, we have gone ahead. We got the PNDT Act amended because of the PIL. The Supreme Court gave directions to the state. The state engaged itself in changing the law, we came one step ahead. The PIL became instrumental in further amendment of the law. Now, one law we got, but till then the technology has gone much ahead. Like sonography, at the 4th month you will come to know the sex of the fetus, but the sex determination takes much prior to 4th month. Test tube baby, the technology is advanced now, and the sex determination is also possible. For that, you need extra efforts. You need extra efforts and you need experts to demand the particular changes in the act. And now, because experts got engaged in the lawmaking process, we now have PCPNDT in the place of PNDT. Prenatal Diagnostic Techniques Act has become now Preconception and Prenatal Diagnostic Techniques Act. So experts' engagement with the lawmaking, experts' engagement with the judiciary is crucial if you wish to really have a good piece of legislation. And as I said, democratic deliberations is ongoing process. This is a classic example. You demand act, you demand law and sit quietly, no. You have to constantly engage yourself with the lawmaking process and law amending process and implementation of the law. I can give another example, next. I can give another example of sexual harassment at workplace. We recently got the act. But before that, see, women are at part of workforce since ages. But we recently got the legislation to prevent the sexual harassment of women at workplace. Why so late? Why so delay? Because lawmakers are made. Women are not organizing themselves and demanding the law, isn't it? And the women in workforce, they are too much getting sandwiched between their domestic responsibilities and workplace responsibilities. They don't have time to get organized and demand their laws, share their concerns and demand the laws. I was talking about the judge-made law. Vishakha guidelines is the example of judge-made law. Any idea what is Vishakha guidelines? That's generally discussed in the newspaper, in the media, so I won't go into details, but Vishakha guidelines is has some basis in Bhauri Devi case. Bhauri Devi, who was the development worker in the grassroots level, who was working for prevention of child marriage, while performing her duties, she challenged the child marriage, that too infant marriage, taking place in a upper caste community in Rajasthan. She was punished. She was punished by the community where the marriage was proposed to be performed, and she was brutally raped in front of her husband and her adolescent son. Beyond that, she didn't get justice from the judiciary because the medical fraternity was manipulated, the police machinery didn't get the appropriate evidences, didn't collect the appropriate evidences in support of the crime, and against the crime, and she didn't get justice. In fact, the comments by the judiciary was devastating. ये कहा था कि हमारी संस्कृति ऐसी नहीं है जहाँ पे एक अपर कास्ट man will rape the lower caste woman. This is blind statement the judiciary passed. I'm sorry to say about it. But she didn't get justice, but this news came in the newspaper, this information about the judgment came in the newspaper, and many civil society organizations came together and approached the Supreme Court through PIL, asking for guidelines to curb the practice of sexual harassment at workplace of women. So there was no act till then. So the Supreme Court passed guidelines which is called Vishaka Guidelines. Because one of the civil society organizations, its name was Vishaka, and the first appellant, the applicant in the PIL was Vishaka. So it is known as Vishaka versus State of Rajasthan. So through these PIL, we got the guidelines, and as the constitutional provisions, the guidelines has the status of law in absence of the particular legislation in that particular area. But from 1998 till recent, we were depending upon the Supreme Court guidelines only. We wanted the legislation because guidelines doesn't have punitive effect. We can't punish a person on the basis of guidelines. We need a proper legislation for that. And through constant pressure from the women's organizations, ultimately we got the law against sexual harassment at workplace. Next. So, if you ask me, environment legislation, feminist jurisprudence is the independent branch of knowledge. Because of such a constant engagement of civil society organizations, constant engagements of women's rights activists with the law, with the lawmaking body, and with the law implementing body, the different separate branches developed under the name of feminist jurisprudence. And another example is Domestic Violence Act. Protection of Women from Domestic Violence Act 2000. 2005, and it's written there. Are we? Okay. No, I'm talking for everybody. So this legislation, I remember I was part of these consultations. The National Women's Commission, State Women's Commission, Human Rights Commission, and civil society organizations, women's organizations conducted state-wise regional consultations, and the demands came from the state, the women itself. Before this present law, a different draft was there, which had provision for anyways. So actually, that draft had provisions for protecting a man who will get violent in self-defense. Now, it is a very funny provision. In the domestic, imagine a situation within the four walls, जहाँ पे husband है, wife है. ये 2003 की बात है. It's not a recent thing. Almost 12 years back. घर में औरत को परेशान आदमी मारता है और उसको एक्सक्यूज दिया जा रहा था बिल में कि वो सेल्फ डिफेंस में औरत को मार रहा है. मेरे सामने आई कुड इमेजिन अ सिचुएशन वेयर अ ह्यूज टॉल वुमन इज हिटिंग अ मैन एंड ही इज hitting back in self-defense. This is ridiculous. I'm thankful to the then government who did not introduce such devastating legislation. And now we have got this legislation, which is outcome of democratic deliberations by civil society organizations. Many definitions are taken as it is. Another example, I can give you many examples, like child marriage CMRA. Child marriage, initially it was 1979 Act, now it is 2005. Child Marriage Prevention Act. So the new act also is a result of constant deliberations, and now also it is undergoing changes. For the government, one ruler declared that the age of marriage will be equal for girls and boys. What is the legally approved, legally allowed age of marriage? 18 and 20. Now our leader said that age of marriage should be equal for women and girls and boys. It should be 21. Do you agree this? The girls have reached here after so much of struggle or maybe family support, but everyone, I mean, many girls are behind every one girl here are struggling to enter the education and they are getting married off. Huh? Do you think the society where girls are married off at the age of 13, 15 till now, they'll wait till 21 years? So, same age of marriage is okay. We want same age of marriage because we want equality in the text of law also. 18 and 21 is not equality. But why 21 for girls? Is there any logic? Huh? Then you are attracting large number of illegal marriages, isn't it? Because people will not stop their marriages of their daughters. They are going to go for illegal marriages. So this calls for the discussion whether how much distance between society and state has to be. Law should not go much beyond where society is, and law should not remain behind of the society. Huh? So there are ample of examples. This Domestic Violence Act, the definition of aggrieved person, definition of respondent has come from the deliberations only. The women demanded for definition of aggrieved person inclusive of a woman staying in a live-in relationship. It was demand for women because, I mean, this is demand from the grassroots. This is demand from the local people that yes, live-in relationship is rampant. You talk about it or not. You talk about your cultural practices, you talk about great culture of India, but live-in relationship is the reality of the life. You cannot just look at it in a very demeaning manner. It's well accepted practice, and the law should incorporate this practice and give protection to the couple in the live-in relationship. So, live-in relationship definition was incorporated in the law because of these deliberations with the society. Definition of violence. Prior to this, we had a criminal piece of legislation, which was IPC 498A or 304B. 304B will take place after the death of the woman. So she will not be benefited by this piece of law. The 498A is a criminal provision. The woman will have to face the risk of losing the marital ties if she approaches the police machinery. So we wanted the civil piece of legislation where the woman can ask for protection of her rights while staying with the husband, while staying in the matrimonial home. So these demands came from the women's organizations. These demands came from the women, that we want justice within our four walls. I don't want my husband and my in-laws to throw me out if I ask for my rights. So it's interesting piece of legislation which is designed based on the demands from people and women. Next. Now, this has been there. This is the experience in the lawmaking. This is the experience in the law implementation. But what is lacking is the institutional mechanism to incorporate people's voices in the lawmaking. There were no institutional mechanisms. There is nothing which will make mandatory to the legislators to hear the people's voices. And so, some mechanisms were required. The legislators will have a great discussion on laws, like the Muslim women's rights related bills, the Kashmir related bills. You will see that hours-long discussions were there in the parliament. But there is no scope for the parliamentarians to come back to the society and ask for consensus from people, isn't it? Then and there you have to take decision. So at such situation, we don't have mechanisms to see that people will participate in the lawmaking. Next. And so pre-legislation consultation is the mechanism which is now available, where at least prior to a drafting of any legislation, people have space to participate in the lawmaking process. Pre-legislative consultations is the very effective tool. It's a way for strengthening democracy. It's effective tool to see that people, at least the people for whom the law is being designed, the stakeholders, the experts, they have space to participate in the process. They have space to say that yes, this kind of law is need of an hour, and this kind of provisions are not at all required for the societal structure. So, these the pre-litigation, pre-legislation consultations. Sorry, I'm again and again saying pre-litigation consultation because that's the practice in the family court in Pune. So, pre-legislative consultations, which is the space where all the stakeholders have space. The law will come to the citizens only after it is passed through the all three hearings, all three discussions in the parliaments, and as signed by the president. But before that, before even it is in a draft position, we want to know that. We want to know what kind of law is designed for us, which kind of provisions are there in the law which are there for us in the democratic state. And so the pre-legislative consultations is important for the lawmakers also and for the society also. For the lawmakers, it is beneficial because through that it is easy for them to manage the discontents, give space to the people so that people are not discontent about the laws. It is beneficial for them because through this they are making the law process more and more inclusive. More concerns are incorporated in the lawmaking processes, and there is no divide between state and people. People won't be calling the state as a dictator because people are part of the lawmaking. There is difference between subjects and citizens. We are subjects or citizens. That will get defined in the process. We are citizens. We are equal to the state lawmakers, and we are not subject who are ruled by some king, and according to his whims and wishes, we are being ruled. Next. So this pre-litigation consultation is a good opportunity for civic authorities, civil society organizations. It's civic engagements. It is a space for us to influence the policymakers and shape the policies according to the changing circumstances. And its basic democratic functioning and democracy and representation is taken care of, and that allows us to bring the democracy in reality. Democracy is not just for voting one day in 5 years. No, every time it gives us opportunity to see that we are part of democratic functioning. Next, how would it go? How is the pre-legislative consultations take place? How is it expected to take place? Next. It is mandatory for the lawmakers to come up with a note which will address the basic issues like why the legislation is being designed, what are the financial implications, what is the broad implementation scheme, then what is going to be the impact of the law, and beyond that, key provisions, because it is before the draft position. So key provisions, proposed provisions, these will be included in the concept note, and this note has to be brought in the public domain. It has to be widely circulated in the different sections of the society. It should stay in the public domain for at least 30 days. so that people will raise their concerns, people will raise their issues with the law, and also proactively tell the state, educate the state what they want as part of law. State, the law legislator also has to be educated, because the anyways, so this is the space for the public, people at large, civil society organizations, to see what they are going to get in the law. Then what is mandatory? As I gave example of Domestic Violence Act, it is mandatory to have consultations with the experts. It is mandatory to have consultations with the lay persons and the stakeholders for whom the law is being framed. So all these consultations are mandatory, and after that, on the basis of the comments and demands and opinions that are coming from the society, the law will be framed. The law will be modified, the law will be shaped. And this is a real democratic process of designing a law for people. Next. This is very ideal situation. Recently, the एक कानून नागरी सुरक्षा विधेयक, on which we raised, many of the organizations have raised their objections. The farmers' law is the example where if you don't take into consideration people's aspirations, the law will not stay there. There are such many examples where the law is not accepted by the people. Now, there are limitations. Even if this is a beautiful democratic mechanism, it is very new. It's a recent mechanism. It is not mandatory for the lawmakers to see that transparently all the opinions are incorporated in the lawmaking. So this mechanism has to be studied, and we need to get engaged with this mechanism and pressurize the state to see that the mechanism is implemented in its spirit and text, and our concerns are seen. We should be able to see that our concerns are addressed while getting the law shaped. Now, the bill is introduced. The bill is introduced in the parliament to make this mechanism mandatory, because 30 days the note has to remain in the public domain is mandatory provision. But after that, whatever the opinions you are receiving from the people, whatever comments you are receiving from the people, whether those comments are incorporated in the law, that feedback is not available. That feedback mechanism is not available. And it's our right to see that our demands are getting shaped in the form of law. If we want to really be democratic, and not just through our representatives, we directly wish to participate in the rule of law, then we should see that this pre-legislation consultation becomes the reality. That there is a detailed note available on the Parliament website on the pre-legislative discussions, pre-legislative policy. This policy has detailed step-by-step mechanisms to call for public opinion on the law. And beyond everything, the lawmakers and the government is also committed to see that they are democratic. We are a democratic country, and the lawmakers and the rulers are also saying that yes, they respect the democracy, and they are willing to see that. Next. They are willing to see that we are really democratic. Recently, in one of the consultations, Mr. Om Birla, who is Lok Sabha Speaker, said that people's participation in lawmaking is much required. It's not adequate. Whatever participation state is receiving is not adequate. So it's state commitment also to seek participation of the citizens in the lawmaking process. So friends, I'm concluding my presentation. Sorry I didn't give any space to you all to raise your questions and raise your objections or opinions in between. Continuously I was talking, but excuse me for that. So I wish a couple of years after your education is complete and during the education also, we'll see you all somewhere in the pre-legislative discussions. Huh? And let's not be a voters democracy, part of voters democracy, huh? But let's make the constitution in reality. Today is the very good opportunity. It's the space day. Day is also a very special day to start something new. So request you all to see that we become a very alert and conscious citizens and not just career-oriented people. Thank you for your patience hearing. Thank you very much.
The floor is open for questions. Any questions from the audience?
इस तरफ किसी का क्वेश्चंस है? Yes. सर.
Thank you so much, ma'am. I'm Amir Sawan. So I have two questions. First question is firstly about the civil society. So one thing I feel is one of the important factor about delivering justice is the restoring dignity of the victim. And many a times what happen is that there is a stigmatization of victim within the civil society, mainly because poor judgment or poor delivery of the judicial process. So what do you think that civil society should develop? Any mechanism or any particular institutions to address this? Second question is more future oriented. So we are seeing the inclusion of generative AI in judiciary, and what happens is that it somewhere affects the jurisprudence, or the idea of jurisprudence, whether a machine can assist in a particular process that is purely human. And when we train a particular AI, we also have to factor in what kind of information we are putting in. So many a times we are not sure about the training modules. There are no framework as such to train the AI modules. So many times there are inherent biases that generate within the system and they come out, and that does not receive well by the population. So what's your opinion on that?
Thank you for raising these very interesting and very complex issues. One is the biases, inherent biases in the system, and the stigma. Stigma is, what you say, it's not just related to law, but generally also for a humane and sensitive society, stigmatizing certain communities, stigmatizing certain people, and stigmatizing certain ideology is a big challenge in front of us. The I can see the faces in front of me, very empowered, very enthusiastic, and similar faces. From your uniform, from your faces, it's really difficult to guess from which caste you are from, which caste you are from, which class you belong to. So it creates a abhas. It creates a delusion that caste is nowhere now. Huh? Unfortunately, this is not the reality. Huh? So many sections of the society are still stigmatized. As far as law is concerned, 377 IPC, we took years to get rid of 377 IPC because sexual minorities are still stigmatized. Huh? The 377 provision is clubbed or used to get clubbed where sexual act against the order of nature was clubbed with same-sex relationship and having sexual activity with the children. Huh? This is insensitive, isn't it? So stigma is very rampant problem which has to be dealt with the laws. But as in the beginning I said, how far the law should go with the society or with be ahead of the society, that we need to constantly be very sensitive about. Pre-legislative consultations, the first comments were asked from the transgender communities few years back, and a good result we got. Because of the demands from the transgender communities, we can see that now the transgenders are getting I-cards, the ration cards, Aadhaar cards, then the public toilet. There is no separate toilets for the transgender community. Huh? They cannot openly intermingle with us. Huh? So this again calls for important deliberations and pre-legislative consultations that the stakeholders has to come up, and people like us who look ourselves as normal, we are not really normal. We should understand. And so if we are going to ostracize certain communities, we are going to look down upon certain people, then definitely we are also part of the wheel where sometimes others are going to look down upon us. So please take care of that. As a sensitive citizen, as a sensitive individual, we should see that there is no discrimination on the basis of anything. One. Secondly, the IA, it has come with a very complex problem, and I'm frankly telling I'm not expert in the technology and law, but yes, pre-litigation consultations is the very beginning of the pre-legislative consultation is the very beginning. We are at the very beginning stage of pre-legislative consultation. So incorporating the technology in IA technology in reaching the judiciary and legislators is a challenge for us. So I will not comment on that. Thank you.